Hey, Wayne Fox, and today I have a video about copyrights. And yeah, I know, but before you hit that back button, let me tell you a little bit about the reason for the video. Recently, I was asked by a group of photographers to present a small workshop on registering your copyrights with the Copyright Office. I thought some information regarding copyright basics would be helpful. As I researched that information, I discovered that despite being a professional photographer for over 40 years, and despite even winning a fairly significant copyright case 20 years ago or so with my previous company, I'm not nearly as protected as I thought I was. So I'm guessing that most photographers out there think they have some copyrights, but if they actually discover an infringement, they'll be surprised to find out that they might not be able to get the damages that they deserve, and they might not even be able to win their case in a significant enough way to make it worth taking to court. First, I need to give a big disclaimer. I am not a lawyer, and I am not offering any legal advice. Everything I'm quoting today, all this information comes from publications of the U.S. Copyright Office itself. So I've decided to divide the video up into two parts. This first part is going to be copyright basics, and the main purpose of this video is to help you understand that you probably need to do some things that you're not doing now if you want to ensure that you have a chance to win any sizable damage claim in an infringement case. Part two is going to go through the actual registration of your photographs with the Library of Congress. That process has been changed dramatically over the last few years. It's now much easier and actually much more affordable than it used to be. So let's go ahead and get on with some copyright basics. So let's start by first defining what a copyright is. This is from Circular 1 of the Copyright Office. Copyright is a form of protection provided by the laws of the United States, and we need to add to that any other country that signed the Berne Convention of 1986, which are numerous, to the authors of original works of authorship that are fixed in a tangible form of expression. So now we need to define a couple things, and I put fixed in bold because that's when we have to define another slide. Let's define original works of authorship first. An original work of authorship is a work that is independently created by a human author and possesses at least some minimal degree of creativity. I believe those two conditions, independently and creative effort, are pretty key in this. I struggle to give an example, but let me relate one that an attorney friend of mine listed in a discussion, although not about this specific thing, but it seems to apply. So you're out taking some pictures of a nice waterfall, and you hike around and you get to a location that think's perfect, and then you move your camera here and there, and you're kind of fine-tuning it, looking in the viewfinder. You're obviously looking at how to crop it. Maybe you're going to change lenses, or if you have a zoom lens, you're kind of moving in and out. And then you get everything all set up. You really like the shot, but you think the light will be better in a few minutes, so you kind of sit there waiting for the light. And you notice some guy a little ways away sitting there watching you what you're doing. And you don't pay much attention to him because obviously that's what goes on out there. But when you see the light getting right and you're just getting ready to start pushing the button, all of a sudden you notice he's got his camera right behind you, just kind of peeking over your shoulder. And he's even gone as far as looking at your LCD screen and putting the same lens on to basically crop it exactly like you are. And as you're taking the shots, he's taking the same shots. So he put no creative effort into that. He's not really working independently. He's working based off of an observation of what you're doing. So this might be an example of somebody taking photographs that don't meet those two qualifications, and therefore they don't own the copyrights to the pictures they just took because you own the copyrights to that creation. So let's suppose instead he walked over with his own camera and he set the tripod up somewhere in your vicinity, attracted to it because he saw you there, but from then on he's deciding his own crop. He's deciding his own timing. So you can see this is a pretty fine line, and maybe this isn't a terrific example, but I think it does serve to illustrate the idea that there has to be some independence and some creative effort involved before you can claim copyright. So what a copyright provides to the owner of the copyright, it provides exclusive rights to reproduce the work, to prepare derivative works based upon the work. So you have the right to make a painting of your photograph, but if somebody else makes a painting of your photograph and it's obvious if it was derived from your photograph, that's a violation of your copyright. Distribute copies of the work to the public by sale or other transfer of ownership by rental, lease, or lending, to display the work publicly if it is a pictorial, graphic, or sculptural work. So a copyright is a property right, and much like your home or your car, you can sell it if you choose, or you can rent it. Now, by renting it, you would license somebody to use that copyright. It can be limited in any way that you would like. You might let a calendar company use it for 1 month and a calendar for 1 year. You might let a website use it as a banner. You could license it for multiple uses. You might allow a company to use it on their website as much as they want, but nothing but their website. Understand that licensing an image doesn't mean you're receiving any compensation whatsoever. That's secondary. Licensing is just a process that gives somebody else the right to use your image for a particular purpose. One critical element, anytime you license an image for somebody else to use, I strongly recommend that you register it, and we're going to get into that a little bit later. And more importantly, you have a written agreement on the exact license that you're granting that person, because it's very common for people to think they can do anything they want with it, and pretty soon they're selling mouse pads using your photograph because you license it for them to use on their website. So when does a copyright go into existence? Again, I'm going to read from the Circular 1 of the Copyright Office. A work is fixed, and remember that word a few minutes ago, when it is captured either by or under the authority of an author in a sufficiently permanent medium such that the work can be perceived, reproduced, or communicated for more than a short time. Copyright protection in the United States exists automatically from the moment the original work of authorship is fixed. So basically, from a photographer's point of view, when we push that button, that copyright exists at that point in time. As soon as that data is written to your card or recorded on that piece of film, it's copyrighted. You do not have to register the image to have it copyrighted, and you do not have to put a copyright notice on any images or files if you publish that image after March 1st, 1989. Now, that being said, this is still a good idea, and in fact, it's really the focus of the video, because failure of either one of those things severely limits what your rights are if you have to litigate a copyright infringement. And we'll get into more of that in a minute. So who owns the copyright? This is, again, from Circular 1. Who can claim copyright? The copyright in a work initially belongs to the authors who created that work. So that means if you're the photographer and you took the picture, you own the copyright. And the exception is works made for hire. When a work is made for hire, the author is not the individual who actually created the work. Instead, the party that hired the individual is considered the author and the copyright owner of the work. So let's talk about what work for hire actually means, because the implication is that anytime someone hires you to take some photographs, that becomes a work made for hire. And it's quite a bit more complicated than that. And most of the time, that's not actually true. If we read from U.S. Copyright Office Circular 9, Section 101 of the Copyright Act defines a work made for hire in two parts. This implies that one of these two must exist for work made for hire to be valid. First is a work prepared by an employee within the scope of his or her employment. So there's two parts to that. One is it has to be an employee. Second, it has to be within the scope of their employment. Well, an employee is traditionally defined by somebody that makes a W-2 wage, that you work for someone or a company and you're employed there enough that you actually have a W-2 wage. Within the scope of his or her employment pretty much means what it says. You are hired for the purpose of taking photographs, or some part of your job you have been designated to take photographs. An example, recently I set up a small little studio setup for an orthodontist to take pictures of his patients when they had their braces off, and he asked me to train one of his employees to take the pictures. I spent a few minutes helping her understand how to position the face so the lighting was pleasant, some basic posing. And from then on, part of her job was to take these pictures for him. So that now falls within the scope of her employment. She wasn't hired as a photographer, so it wasn't quite as obvious as other circumstances, but it still was part of her job duties, and she accepted those. So maybe a theoretical example, you're a software developer working for a company, and one day your boss walks in and says, hey, you have a really nice camera and you take really nice pictures. Would you take some pictures of this garden that we just installed so we can put them on our website? So even though you're an employee of the company, the pictures you take are not within the scope of your employment. You're hired to be a software developer, and just because the boss asked you to do it and you did it as a favor to the boss, and even if you did it on company time, you most likely retain those copyrights. Now, like anything else with law, when you get into specific circumstances, there always seems to be different interpretations. So that example may or may not hold up in court, but I think it illustrates the point. The scope of the employment is a critical part of this part of the law. So here's part 2. A work specially ordered or commissioned for use as, and in the law, these 9 circumstances are defined: a contribution to a collective work, a part of a motion picture, a translation, a supplementary work, a compilation, an instructional text, a test, as answer material for a test, or an atlas. Goes on to say, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. So those are a lot of conditions that have to exist before a work made for hire can actually be valid. And critical of that is the written instrument signed by them that the work shall be considered a work made for hire. One other implication is that you can't sell a copyright on a picture that hasn't been taken unless it's expressly agreed to in writing beforehand. Kind of critical. So to make this a little more confusing, let's read from Copyright Office Circular 9. And this is actually something that came out of a Supreme Court decision. A work created by an independent contractor can be a work made for hire only if it falls within one of the 9 categories of works listed in Part 2 above, and there is a written agreement between parties specifying that the work is a work made for hire. Otherwise, the photographer is actually the one that still owns the copyrights. So in summary, let's just talk about the 3 conditions that must exist for a work to be considered a work made for hire. All 3 of them must exist. There can't be one left out. First, it must be specially ordered or commissioned, so that you have to be hired to perform a specific work. That specific work must fall within the 9 categories defined by the copyright law. And I'll be honest, most of the time a photographer is hired, what they're being hired to take a photograph of does not fall within those 9 categories. And that's why the photographer retains the copyrights. And finally, there must be a written agreement signed by both parties before the work commences that it is a work made for hire. So once the photographs are taken, you can't then turn around and sign an agreement that said the works were made for hire. And if you are asked to sign an agreement after the fact, and you do, it is invalid because that is not allowed within the law. Obviously, you can sign a license agreement or a transfer of copyright agreement, but then the whole works for hire conversation is irrelevant at that point. Now, I'm not going to get into this because it is, I've read so many court cases and this is such a mess, it's not funny. But most of the time, it's pretty easy to prove that unless you agree in writing before you take the pictures that you have yielded the copyrights to some other party, you retain the copyrights. So let me sort of try to summarize this. And this is my language. I'm not reading from any quote now. The act of hiring a photographer does not in and of itself transfer the copyrights from the photographer to the person hiring the photographer, and unless there is a written contract before the photographs are taken and the work the photographer is being hired for falls within one of the 9 categories of works listed in the copyright law, the copyright most likely remains with the photographer. So the key to most of this language to me is the written agreement. Obviously, even if you are doing work that falls outside of those 9 categories, but you've agreed beforehand that everything you shoot belongs to somebody else and it's in writing, I think that ethically and even a court will probably support that because you agreed beforehand, they do own the copyright. But as you can see, it's pretty convoluted and pretty strange. For most photographers being hired to do a wedding or some other event, it's pretty clear in the law that that doesn't automatically give the person hiring you the copyrights to those images. So if you thought that was confusing, now I need to talk about fair use. And let me preface this discussion by saying it's fairly important, and the reasons why is that if you have an infringement case, there are normally only 2 or 3 things the defense can try to throw at you to try to reduce the damages or actually get away with it doing it. And the one they try to use to get away with doing it without any damage is this idea of fair use. It is possible that somebody can use your photograph without your permission and even without your knowledge. Generally, these are circumstances that are deemed in the best public interest, and we'll talk about some of those. But the concept of fair use is very spelled out in the copyright law as well. And I'm going to read right from Section 107 of the copyright law itself. Limitations on exclusive rights. Earlier, it said the photographer had exclusive rights. Well, then they turn around and say there is some limits, and the fair use is what it's labeled as. The fair use of a copyrighted work, including such use by reproduction and copies for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, is not an infringement of copyright. Continuing, it says, in determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for a non-profit educational purposes. So if a teacher in a high school or a professor used photographs in teaching their class, that would fall inside of fair use. But if somebody was doing a YouTube video and they used some photographs that they didn't own, and then later say, well, I'm doing them for educational purposes, understand that the law says it has to be a non-profit educational purpose, and non-profit is a legal status granted by the tax code to an institution. It just doesn't mean you're not making money. So to fall within fair use, you have to be a legal non-profit organization and an educational organization. Good example is there are a lot of hospitals that are non-profit, but they're not educational. And even a university that has a hospital, the photographs can only be used in the educational part of their organization. They can't go take a bunch of pictures and throw them on the wall for decoration and claim it's fair use. The nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So we talked earlier about a derivative work, which is obviously something that was derived from your photograph, but it is possible that somebody could use a very small section of a photograph in creating some other work, which is deemed, your portion is deemed insignificant and only part of a bigger whole. So that's actually can be considered a fair use. And finally, the effect of the use upon the potential market for or value of the copyrighted work. So if their use of the work actually damages the value of the work to you, that might fall outside of fair use as well. These are all things that have to be considered when it's fair use. And like I said, this will be one of the main arguments somebody would use in their defense to avoid damages. So much like our previous discussion on works for hire, fair use is a little fuzzy as well. Let me mention a couple of things. One might be the thought of how does a search engine like Google get away with putting everybody's pictures on their search results? Obviously, every photograph taken is copyrighted. Google makes no effort to distinguish that. That's been determined a fair use. And I guess if you want to look at it from one perspective, they actually didn't copy the image. They just found a website that did. If you see your image on Google and it's not coming from your site, then it's from whoever did the copying. It would be nice if they could actually search those, kind of like Digimarc Guardian did, and notify people when they find their photographs, but I guess that would be sort of anti-Google. So now let's talk about registration. And registration is actually a pretty big deal. I used to think that I only needed to worry about it if I caught somebody infringing. And while technically that's true, it's more important than that. This is from the Copyright Office Compendium, Section 202. Although registration is not required for a work to be protected by copyright, registration is a prerequisite to filing a lawsuit for copyright infringement involving U.S. work. Okay, yeah, that makes sense. Before you can go to court, you have to register it. That's what I always thought. But let's keep going here. Although registration may be made at any time before copyright expires, or any time before bringing infringement action in federal court, as discussed in Section 202, a registration is a prerequisite for seeking statutory damages and attorney fees in an infringement action. And it gives another qualification. It goes on to say, to pursue these remedies, an unpublished work must be registered before the infringement occurs, while a published work must be registered within 3 months after publication or before the infringement occurs. So if you fail to register within 3 months of first publishing the image or before any infringement occurs, you can only seek actual damages. That means you have to prove you lost money or that they made money and how much money is involved. It also means you can't recover attorney fees. So you have to cover that in all of your damages, because the only way you can gain attorney fees is also if you qualify for statutory damages. If you register within 3 months of publishing the image or before any infringement occurs, you can choose to pursue actual damages or statutory damages. Now, statutory damages are a really big deal because those are set within the law. And a lot of times that's a much bigger number and can even be quite punitive. Minimum damage on statutory damages is $750 per infringement, up to $30,000 per infringement. With actual damages, you have to prove what you lost or what they made. So it's pretty obvious that registering in a timely manner is extremely beneficial if you ever find one of your photographs copied. In my mind, if a work is not registered, it will be difficult to win a large enough claim to make the legal action worthwhile unless the infringement is egregious or the infringing company is quite large and should have known better. Now, I'm not reading a quote there. That's just me saying it. Obviously, if it's very egregious, meaning you can prove that they generated a lot of revenue from it, or maybe it's a really big company and they just decided it was easier to pay you rather than follow through in court, it's probably not going to pay to actually take a copyright case to court if you haven't registered in a timely way. And I'm pretty sure that nearly all photographs taken by professional photographers are currently not being registered with the Copyright Office. So if you're browsing the internet and you find some company is using your photograph in an ad and you didn't register it, you might have really hurt yourself. And the whole reason for this video is registration is a different process than it used to be, and it's not as hard, and we'll get into that in a few minutes. So let's talk for a minute about infringement. From what I can tell in all of the research I did, I concluded that there are 5 things that you can do if you find somebody infringing on your copyright. Now, obviously, there are probably some other things you can do, but I think these are kind of the big ones. Certainly, you can choose to do nothing. You might decide it's frivolous. You don't really care. You might even think it's kind of cool. If they didn't give you credit, you could ask them to go ahead and give you credit. Say, hey, you used it. Least you can do is put my name on it. They might oblige. They might not want to take it down, and you tell them that they have to. And the nice part here is if it's a use on an internet website, they really don't have a lot of choice, because if they say they're not going to take it down, you can file a DMCA takedown notice, which stands for Digital Millennial Copyright Act. And that is filed through the ISP that hosts their site. The ISP now has to get in the middle, and unless they can validate to the ISP that they've got a fair right to use it, the ISP must quit broadcasting the image, so most likely they will just shut the site down. Now, we talked a few minutes ago about fair use, and one of the things you have to do before filing this notice is make a determination that you do not believe the photograph is being used for fair use. Most online uses don't fall within fair use, so you can file this DMCA takedown notice. Certainly, you can demand payment. You can say, hey, this is what it's worth, send me some money. or hey, you made a lot of money off of this, I deserve a piece. You can even have an attorney send that for you, which might make them bristle a little bit, but it'll put a little bite into the thing. And I would hope that they would call the attorney before they would just refuse, to see if there's a way to negotiate out of it. And of course, you can file suit. Hopefully you dotted your I's and you crossed your T's, you registered in a timely way. And if it's time to go to court, you need to find a competent attorney who specializes in copyright law. Hopefully one that's even dealt with photography infringements before, so he has some experience. And you can sit down with him, lay out your case, and make a determination on, first of all, whether it's worthwhile and how to proceed. As I said in the beginning, I'm not offering any legal advice. If you think you've been infringed on, then I would recommend you talk to a good copyright attorney. So what can you do to protect your copyrights, or more importantly, ensure you can achieve maximum damages in case of an infringement? First thing I would say is embed your copyright information in the file metadata. Very easy to do when you import them into Lightroom. I have another video on that, but it's really just as simple as clicking a little pop-up menu whenever you import images from off your card once you've set it up. I would include your name or even a full copyright statement on the photograph. The copyright statement includes the word copyright or the copyright symbol, the year, and your name. There's a pretty important reason that you want to consider doing this. We're going to read from Circular 3. Copyright notice is optional for unpublished works, foreign works, or works published on or after March 1st, 1989. So it's specifically optional, and there are people that tell you it won't. If there's no copyright notice, then it's free game, and that's not true since 1989. However, works first published after March 1st, 1989 may need to comply with statutory formalities to prevent a defendant from invoking an innocent infringement defense in a copyright infringement action. Now, this innocent infringement defense is probably the most common defense that a lot of people will use, especially smaller infringements, mostly because it can reduce the damages that the court will award pretty dramatically. So we mentioned earlier that statutory damages are anywhere from $750 to $30,000, but a defendant who successfully wins in an innocent infringement case, that damage can be reduced to as low as $200, and that's a pretty big deal. Now, if you kind of go the other way, if on the other hand you have the notice on there and they intentionally remove your notice, and so the violation is considered willful, the maximum damages go from $30,000 all the way up to $150,000 per infringement. But it's very difficult to prove willful infringement if you didn't have a copyright notice or at least your name on the photograph. Now, logic tells me that if they didn't take the image and they didn't negotiate a copyright release for it from the person that did, they still knew it wasn't their image. Every single image taken on every single camera, including cell phones, is copyright protected from the moment it's created. So unless you took it, or unless you know who took it and got their permission, you know you don't have the right to use it. So I'm not sure how this innocent infringement defense would ever work, but I actually read a case where somebody that ran a film company used some photographs, and of course you'd think a person that runs a film company knows quite a bit about copyrights, and this is the defense he used, and he won, and damages were dramatically reduced. Doesn't make sense to me, but obviously that's something you have to consider. Another thing you can do is register them as soon as possible. We've already talked about why that's critical. It really is important that you register them before any infringement occurs. That's just the most logical thing you can do. And the second half of this video talks about how much easier that is and how much less expensive it is. You could embed a Digimarc watermark in the image. Digimarc has a plugin that's available through Adobe's website. This link tells you how to use it. This watermark is pretty much imperceptible in the image, and yet if you read the image using the opposite plugin, it will see if there's a copyright in the image. Unfortunately, they used to have a service that scoured the internet for these watermarks and would notify photographers when one was found, but they no longer offer that service unless you're a pretty large company. However, there are services that do. Now, these cost money, and I would think for most people it's probably not something that's worth the investment. If you're a stock agency or some other type of company, I would think it would be useful. But these are three you can check out. They have different levels of service and different ways that they work, and I'm sure there are other ones out there. So what you have to do is determine if it's worth your time and effort to register and maintain your copyrights. If you decide it is worth doing, you don't have to register all your images. You need to decide which ones you need to register, which ones are most likely to be stolen because they're prevalent or more accessible. I certainly don't register everything I shoot. Typically, when I go out on a shoot, I'm at a location and I might get one or two keepers, and I only register the keepers. If you're a wedding photographer, a sports photographer, you maybe shoot way too images to afford to register them. It's something you'll have to decide. But you might find that every once in a while you get an image that's pretty impressive, and maybe it's worth registering because it might be valuable to you. If you're going to let anybody use one of your images on their website or anything else, I strongly recommend you register it first, because what you'll find is that they'll honor your copyright, but then somebody's going to steal it from them. This happened to me. I licensed the image to be used in an article, and I allowed them to also post the image on the online version of the article. And later I came across somebody that had taken the image from their website and was using it as the banner for their website. So let me finish this first part of the video by talking about a few misconceptions that most photographers have. Most photographers think it's quite expensive to register their pictures, and also they think it takes them a lot of time. And because of those two things, they think there's probably little to gain. We've already covered in this video a lot of information about if there's little to gain, and I think I've proven that it's more important to register them than most people realize. As far as expensive, you can register up to 750 photographs at the same time for $55. It's not quite that simple. It depends on if they've been published or not. But most of the time you can register a fair number at the same time in one registration. And it only takes about an hour the first time you do it, especially if you watch part 2 of my video, which will walk you through the steps on how to create the various parts that you need, including what you need to submit to the Copyright Office. So those are some misconceptions, and I think that after watching the video, maybe you're motivated to at least give it a try. I encourage you to watch part 2 of the video, where I will go through that process of registering them step by step. I don't think it will be nearly as long as this video. I apologize if this was kind of long, but I'm trying to make sure I didn't leave anything important out and the information is useful and I didn't say anything that was incorrect. I've tried to hedge myself as much as possible, and again, I will say I'm offering no legal advice, but everything I quoted was from the Copyright Office itself or from the law itself, and I did a lot of research, and I'm pretty comfortable that at least this gives you some guidelines and thoughts you might want to consider in protecting your own copyrights. So hopefully you'll watch part 2. Thanks for watching.